Yeah.
Sure. Thank you so much. Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Eligibility and Budget Review Committee. Thank you for joining us. We will begin now. I think we were scheduled at 9. We're using Zoom with the goal to foster a more inclusive environment, effective meeting. If you would like to comment during the meeting, please use the raise hand feature. To use the raise hand feature by phone, dial *9 on your phone's dial pad to raise your hand, and to do the same to lower your hand. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. Going forward, all Legal Services Trust Fund Commission and committee meetings will be recorded and posted to the State Bar website. As a friendly reminder that this is a video conference, and please be aware of your surroundings behind you. Some quick troubleshooting tips. For those using Zoom on a computer, when on mute, holding down the space bar will temporarily unmute. And if you use your phone to dial into this meeting, please be sure your computer's microphone is on mute to avoid any audio feedback issues. And lastly, while joining video via computer is highly recommended. If an individual loses audio, they can always call in separately using the Zoom conference number.
Great, thank you, Michael. And it looks like we have Bonachet, so why don't we go ahead and take roll call. I think you're on mute, Erica.
All right.
That's okay.
Connolly?
Present.
Cloggy?
Present.
Fightmaster? Bennett? Blakemore?
Present.
Klein? Meeker? Okay. And then liaisons, Selena Copeland? Bonnie Huff?
Yes.
And State Bar.
And Melanie is here as well.
Oh, great. Thank you.
Or was here.
And then State Bar staff, Dawn Wing, Brady Dewar, and let's see, Michael Chang, and Corinne. Okay, thank you.
Great. And thank you to Catherine, Bonachet, and Pamela for making it so we can have quorum and get through these tasks for today. I appreciate it. Let's go ahead and start with are there any public comments?
There's Zach Newman from LAC is only attendee, public attendee.
Okay. Zach, do you have anything you'd like to share, or are you?
No public comment today. I'm attending for LAC. Thanks, everybody.
Oh, okay. In lieu of like Selena.
Yeah, exactly.
Got it. Okay, perfect.
Thanks.
Thanks. Thank you, Zach. Sorry to call you out. Okay, great. If there's no other attendees or no other public comments, why don't we go ahead and move into the approval of the meeting and summary action items. Does anyone have any concerns or comments on those? Okay, hearing none, do we have a motion to approve them?
Catherine moves.
Okay.
I'll second it.
Thanks, Bonachet.
Connolly,
Yes.
Cloggy,
Yes.
Fightmaster, Bennett, Blakemore,
Yes.
Klein, and Meeker. Okay, the motion passes.
Great. Why don't we move into the updates?
Sure. Okay. So we have a few updates this morning. The first one is a report out on the closing out of family legal assistance at CHOC Children's, their grants from 2021. This organization was a legal services project grantee from 2019 to 2021. They last year were not found eligible. They were unable to provide an audited financial statement and didn't move forward in the application process. And so 2021 was the last year that they received funding from IOLTA and EAF funds. We're currently working with them to close out their final reports from 2021. They experienced a significant turnover. It was a very small organization to begin with, and then the former head of the organization has left, as well as I think their main staff attorney. And so those who are winding down the operations are trying to access the information that we need in order to complete their reporting. They've been facing some difficulties. So State Bar staff is still working with them, but they are engaged and wanting to comply. So we have let them know that if they don't submit their reports, that eventually the State Bar would seek reimbursement for the funds that haven't been accounted for. They've verbally informed us that they have spent all the funding. As you can see, even in their first quarter last year, they reported spending all of their IOLTA funds and then the majority of EAF. So really, we're just waiting for them to complete the reports, and then their evaluations, their case summary report, which gathers demographic data and case information, their EAF report, and then which deals specifically with their activities under the EAF grant, and their main and economic benefits evaluation, which has to do with their case outcomes. They appear to be completed, but they haven't been submitted. So we're following up to make sure that those are finalized. Yeah, so just kind of an update that we're still working with them to close it out, but that we do anticipate hopefully by the next meeting that this will be finalized. So. Any questions about that? Concerns? Okay.
Thank you, Erica. Sounds good.
Yeah. The next update is about some monitoring visit findings from monitoring visits we've already conducted in 2022. So with two organizations that we had monitoring visits with, McGeorge School of Law in Sacramento and then Open Door Legal in San Francisco, they had some fiscal findings that will impact their 2022 grant award. So in the case of McGeorge, there had been some inaccurate recording of time for one of the staff at the clinic that also engages in teaching time outside of the clinic. And so some of that time had accidentally been recorded as clinic time. And so that's been corrected. Our staff believes it was a genuine, a human error. And based on our recalculation of how much should have been considered non-qualifying, they'll be returning or we won't be dispersing about $5,446 of what their original award was. We're reducing it by that amount. So that funding will remain in Sacramento for the next funding cycle. And then with Open Door Legal, with their monitoring visit, we learned that they've been engaging in building a case management system, kind of doing in-house product development on the CMS, and with the goal of marketing it for a fee to other legal aids. They're in beta testing for that right now. The finding was that they didn't have a fund accounting system in place. So we've asked them to do that and then to calculate, because we don't know at the moment exactly how much was spent on this activity, but we've asked them to calculate those expenses and report back to us so that staff can do the same thing they did with McGeorge to calculate just how much should have come out of their qualifying expenditures. So we anticipate some amount may be returned, which again would be redistributed in the next funding cycle, but we're not sure at the moment how much that is. they have 60 days to respond, and we just issued that report earlier this month, so we won't know probably until sometime in August. But any questions or concerns about that?
Do you, for Open Door Legal, because we haven't heard their response yet, we're not aware if they're gonna give us pushback on.
Yeah,
Yes.
that's right. We don't
Okay.
we don't know yet. McGeorge was receptive, but with Open Door Legal, we don't know if it is possible that they will contest that finding, and they may argue that it should be considered a qualifying activity. And in which case, if they do, if there is that disagreement between staff and the organization, that is something that we would need to bring to the committee to look at more in depth. At the moment, it's staff's opinion that shouldn't have been a qualified expenditure, but if it is contested, that is an example of something we'll bring to you to look at.
Did they provide you with any information during the visit about why they thought it was qualifying, or it was just they didn't have a way to track it because of not a fund accounting system?
Yeah, I mean, I think they made, general comments that obviously this is going to, the concept behind the CMS is like to have better integration across the legal aids, so that, if one organization can't serve someone, that the referral process will be easier, and that they're connecting indigent persons to services. And so there is some aspect of, that it would be connected to the delivery of legal services. I think the concern from staff was more on the, charging a fee for it, and basically it being a revenue generating product. But yeah, so I don't know if we haven't gone super in depth on that, but that is what I recall in terms of their commentary about why they thought it should be considered included at the time, but that they were going to take a look at it more closely.
Thank you.
Okay, thanks, Erica. We'll look forward to hearing what ends up resolving with this.
Sure. And then the next topic is the 2023 IOLTA and EAF audit extension requests. So just as some background or reminder, audits are required as part of the IOLTA and EAF application process. Organizations have a deadline of May 1st to submit the audited financial statements from the prior fiscal year. Staff has discretion to grant an extension through the application deadline, which typically is around 2 weeks later, upon a written request from the organization. Anything beyond that date, so this year it was May 16th, anything beyond May 16th would require commission approval. And what the schedule of charges and deadline says is it needs to be upon a showing of extraordinary circumstances. There was a recent commission recommendation or decision to have some more flexibility there and have discretion to accept late audits that don't have extraordinary circumstances when conditions are imposed or there's corrective action in place. That has not been finalized. It still needs to go out for public comment, but that is kind of the most recent development in terms of late audits, that there would be some flexibility to accept them without extraordinary circumstances under certain conditions. And then if you recall at the last meeting, we did sort of an overview of the organizations that had anticipated that they wouldn't be able to meet the deadline. And so at that meeting, the committee voted to delegate responsibility to a working group comprised of Erica Connolly and Catherine Blakemore to review these requests and make the final recommendation to the commission. So that's why this is in the form of an update rather than a voting item, because Erica and Catherine will be reporting out on their recommendations.
Great, and I think Catherine, you were going to present on our decision making. By the way, just as a heads up, I think Banashe said she had to drop off. Brady, does that affect our ability to vote later?
I have not been paying attention to the
Sorry.
quote. I mean, to the quote. If we don't have quorum, we can't vote.
Okay, I'll ask her if she can jump back on when we're ready for
I mean,
votes.
are we right on the knife's edge?
Yes,
Mhm.
we don't have, without her, we don't have a quorum.
Yes.
Okay.
So
Got it. I will ask her if maybe we can like put everything and then ask her to just jump on for some votes once we've sort of decided, okay? Thank you.
Okay, so we received, I think it is 10 requests for extensions. I think the materials include the letters that were sent. Carol did a great job of getting request letters from each of the programs that were requesting extension that outlined what the circumstances were. Erica Carroll, and I then reviewed all of those. And what you see on these two slides is kind of the status and recommendation. So what we did was approve the request for all the organizations except one who was a new applicant and in the end didn't really respond to staff's request for additional information. But with some of the organizations, you'll see a little asterisk next to the approve. And what we did was ask them to, in a letter, identify how they were going to ensure that this would not be an ongoing problem for them to get their audit in on time. And from my perspective, I think it was a really effective process. We both, we were able to look at the information, approve, but also take the next step of letting programs know the importance of compliance and asking them to identify how this would not happen in the next year. So you'll see, this is now the second group of individuals. You'll also see that for the vast majority of them, we have received now the final audit. There's a few outstanding ones. All of them will be received by June 30th, which from staff's perspective works for being able to confirm that the audit, there's a reconciliation with the program reported and what the audit's saying, so that there won't be that kind of that kind of difficulty. The one at the end, Santa Barbara County Immigrant Legal Defense Center, was a new applicant. They requested 10 days to obtain a reviewed financial statement. We granted the 10 days from that is what they wanted, and they never followed up to staff's request of the status. So we're not recommending approval of that. We're recommending that that one be denied. So the action will be to approve those noted here, which I think are 9 if I counted correctly,
Yes.
and one denial of Santa Barbara County Immigrant Legal Defense Center. And I'm sorry, I'm not clear. Does this just go directly to the commission? We're just updating people. So
Yes.
I don't think you actually need to vote on this. It'll just be a discussion at the full commission meeting this afternoon. But we wanted to make sure you understood our process and had the chance to ask any questions that you might have about the decisions that we made as the working group.
Pamela, excuse me, Pamela, do you have any questions for us? I can't see her, so I assume.
She's there and she took herself off mute. I don't know if she has. Do you have any questions, Pamela?
No? Okay.
Perfect.
Thank
Thank
you.
you.
Great. Thank you, Catherine.
Really, I thought it was a good process and really appreciate the staff's time in getting us the information and following up with programs to make sure we had the second set of letters that we needed. So really appreciate you, Erica Carroll.
Yeah, and
Yeah.
thank you both, Catherine and Erica. It was really an efficient process, and I think it's very helpful to staff to, have that support to impress upon organizations the importance of meeting these deadlines so that we can, help them get their grant awards on time or their allocations on time. So thank you.
Yeah, I also thought it was a good proof of concept on our letter idea, sort of interim steps. And I thought they did a good job of, in general, providing some good details and some thought about what to do for next year. So yeah, and thank you to Erica Carroll and all the staff for the help with this, and to Catherine. Okay, what's our next? Support center deeming.
Yes, so Just a sort of a quick update or overview on support center deeming. So, we have qualified legal services projects and support centers. Support centers are the organizations that provide the technical assistance and training and advocacy support to QLSPs. And so under the statute, support centers that were not in operation as of December 31st, 1980, they have to go through this process that we call deeming. They need to be deemed of special need by a majority of the QLSPs. So we institute this practice or implement it every 3 years on a rotating basis. This year, we actually only have one support center that needs to be deemed, which is the Center for Gender and Refugee Studies. So what we do is we distribute a ballot to all of the current qualified legal services projects, reporting out what support services that CGRS has said they provided in the prior year. And we ask them to vote on whether they would consider the services provided by CGRS to be of special need or of help to them as an organization. So in order for the organization to be deemed, we need to have a majority of the QLSPs vote yes. So I believe that's probably, about 38 or 40 of them. So it's about a month-long process. We'll be releasing that ballot in a few weeks. And then at the committee's August meeting, we'll report out on whether, if they met that requirement or whether any further action is needed from the committee. If for some reason they weren't deemed by the QLSPs. So.
Great. Thanks, Erica. I'm going to ping Bonachet and let her know, because I think the next things that we have are all vote required.
Yeah.
So just give me 1 second.
Sure.
Okay, I just pinged her, so hopefully she'll be joining us back again. Are there ones that we, in case Bonachet is time constrained, are there ones that we need to prioritize getting done in this meeting, or do they all need to get done this meeting? I'm just trying to see if we should move any around.
Yeah, it would be ideal to do them in this meeting, but for example, the ILAW reports, I don't think any of these organizations are at risk of not meeting primary purpose, for example, if they needed to deduct something later. So that would be fine if we dealt with it, for example, in July. If you found something non-qualifying, staff would still have time to follow up with them to deduct the amounts that they spent on these activities. So
okay.
Is it possible for us to go through the items and make a recommendation, and Bonachet might be able to join us at the end to vote? I mean, even if she abstains from voting, it'll be fine.
Yeah, I pinged her and she said she was not comfortable voting unless she was part of the discussions, but I think maybe what we could do is, and I just pinged her to let her know that we were moving into those discussions. My suggestion though is maybe we could start the discussion on the ILAW stuff. I think, and just see if there's questions or concerns that we can kind of start debating. The other thing is, I feel like the last two look like they're probably pretty easy ones to delegate authority for the eligibility review conferences. So maybe we can kind of knock out those two pretty quickly. And then the ILAW ones, we can maybe start the discussion, and as she joins, she can kind of catch up with us. So yeah, Eric, why don't we start with the ILAW, if that's okay?
Mm-hmm. Sure. The item about the remaining 2021 ILAW reports, we first addressed this at the last meeting in April, and there were some outstanding activities that needed some more information or some follow-up. So we've provided that information in the meeting materials. Just a reminder, ILAW is impact litigation and advocacy work activities. When organizations provide services or engage in impact litigation cases or advocacy work on behalf of indigent persons as a group or on behalf of a class of persons, they need to demonstrate that it would primarily benefit indigent persons. In the case of QLSPs, support centers they have broader discretion in that they need to show that it would be of benefit basically to the qualified legal services projects that they're advocating on behalf of. So with QLSPs, they need to show it's legal services is the first part, and then for the benefit of indigent persons primarily. In our eligibility guidelines for QLSPs, the work needs to be performed in California. So the first issue that you see here was that public counsel had reported out-of-state impact litigation cases. And there was discussion about that with a representative from public counsel at the last meeting, and where the committee wound up was asking them to identify their expenditures on those cases that could be tied to work on behalf of indigent persons in California or casework in California, which at the time they thought they would be able to do. And so they were given the opportunity to come back to this meeting and provide that information. But based on follow-up from staff, public counsel went through this exercise to try to pull out those expenditures and reported back that they were not able to adequately separate out those expenditures or to tie them specifically to California work. So they voluntarily withdrew their request to have that be found a qualifying activity. And they've since deducted the expenditures on their IOLTA EAF applications. So that's no longer an item that the committee is going to have to address. And then the other activities were reports that staff had indicated the grantee demonstrated or was asserting that there was a disproportionate impact on indigent persons. As I just said, usually we're looking for it to say it primarily benefited indigent persons and for the organization to show data or evidence that that's the case. And by primarily, we consider 50% or more to be the standard. But the committee also has historically looked at activities where the organization says it's, maybe not the majority of persons impacted are indigent, but there is a particular benefit or a disproportionate impact on indigent persons that would make it a qualifying activity in their eyes and why they engaged in this work. So at the last meeting, I believe in the memo, it referenced about 15 activities that the committee asked us to bring the reports themselves to the committee for review because we had summarized them at the last meeting. And so those were in your materials. We removed a few reports. The reason for that being that they were either impact litigation activities that we, upon review, realized they had indigent plaintiffs. So that's typically considered a qualifying activity. So we pulled those out. And then there were one or two that basically said, we understand that the activity was, larger, but we wrote one letter specifically from the perspective of, the clients that we serve, so they weren't necessarily advocating for the activity on a broader scale, but just identifying, one piece of the advocacy that they wanted to comment on. And so specifically from the perspective of their clients' needs. So those were removed. But the ones that were in your materials are all advocacy activities. So none of them are impact litigation work. And I can go through each of them a little bit more in depth. So Asian Americans Advancing Justice submitted an activity for their API equity budget work. And this report articulated that they were advocating for additional resources for survivors of hate violence in the Asian American Pacific Islander community. Their perspective was that even though these resources would be available to anybody who's been a survivor of hate violence, that it would be most beneficial to indigent persons. For example, the bill would make mental health resources available for free or low cost. And so indigent persons who might not have insurance or might not be able to afford seeing a private mental health therapist, that they would be able to avail themselves of these resources. And so they felt that it was a disproportionate benefit for indigent persons by making sure that these resources were included in the budget. They also provided some internal data regarding phone calls that they received on this topic, that the majority of the phone calls that their organization received were from indigent persons, either older adults or persons who would be considered indigent based on income. So that was anecdotal, but it did tend to support their argument that this would be disproportionately beneficial for indigent persons. And then the next activity was East Bay Community Law Center. They had an advocacy activity for consumer protections. Their goal was to increase transparency around debt settlement and reduce predatory lending practices in California. And so this could impact anybody who's dealing with a debt settlement issue. But they did cite some evidence that a significant proportion of individuals affected are seniors or low income, and older adults are considered indigent under the statute, regardless of income. So that's another characteristic under which a person could be considered indigent. And they also cited, folks who are on a fixed income or low income would be even more heavily burdened by needing to deal with these predatory lending and debt practices. So that was their perspective about the disproportionate impact on indigent persons for that activity. And if you want to talk about any of these individual activities, please feel free to stop me. And then the third one was Legal Aid Society of San Diego, also had a consumer advocacy activity. They meet quarterly with the Department of Financial Protection and Innovation regarding the regulation of debt collectors in the state. They also reported, their belief that most consumers in debt collection are indigent, but without a particular source or evidence to support that. And they also, reported that they were representing the legal aid perspective in these meetings by providing vignettes or data from their own agencies regarding the needs of indigent persons when dealing with debt collection. So, and again, similar to the East Bay Community Law Center activity, their perspective was that this would be, debt collection for indigent persons is going to impact them even more heavily than individuals with higher income. Pam, I think you raised your hand.
A quick question. What actual, what actual debt were they coming across for the indigent? What actual debt were they coming across or finding that they had that they needed to represent or to help them to better understand?
As far as I know, with those two activities, I don't think they were confined to a particular type of debt. I think it was just the fact that persons who are indigent may not be able to, pay back their debt. And so they're subject to these predatory lending practices that say they're going to help you get out of debt, but then you're actually subject to increased fees, which compounds or worsens the problem. And we're talking about the impact that individuals may need to be making choices, for example, between, purchasing medication or food versus paying off this debt. And so that was kind of the nature of it, but there wasn't, from what I recall, there is one activity that deals with medical debt, but these two that I was just addressing, I don't remember them talking specifically about what type of debt was being addressed. I think it's just generally speaking.
Thank you.
Mhm. And then the next activity was mental health advocacy services, which provided a letter in support of AB 124, which was advocacy on behalf of survivors, domestic violence and sexual assault regarding criminal record clearance. Again, they indicated that, for indigent persons, this would improve access to housing and employment resources and reduce barriers to accessing these resources by helping individuals clear their records, and cited some statistics about the proportion of survivors of DV and sexual assault that would be impacted, who they also claim the majority would be considered indigent, but it didn't have specific data as to the indigency of the individuals. Yeah, Erica.
All right, just a quick question. So this is to clear the criminal records of victims of DV and sexual assaults?
Yeah.
That's the nature. Okay, got it.
Yeah.
Thank you.
Yeah. So it would be criminal record clearance for individuals who essentially were forced into committing certain criminal activity, or who were accused of committing certain criminal activities when not of their own volition.
And does that falls within the expanded definition of civil legal services, right?
That was my understanding, that this would be included because it's not requiring a finding of factual innocence. So I think that, yes, that's correct.
Right, and this is legislative advocacy, right? This isn't defending them on the clearance.
Right.
So it's legal services, even if.
And maybe Eric, I know the legislature has approved funding for a new consumer debt funding stream. And so I don't know, my guess is you haven't thought about sort of the parameters of that program yet, but it seems like whatever's approved here sort of becomes kind of forward thinking about activities that would be approved. Is that right? And I guess I just want to make sure that, anyway, maybe when we get to the end, whether staff has any concern about these activities and any impact on kind of how that program, what's allowed under that program.
Sure. Yeah. And I think Dwan may be able to join the call in a little bit, in which we might have more to say on that as well. So.
Okay, thank you.
Yeah. The next two activities were from Neighborhood Legal Services. One was a comment on the state budget, in particular relating to resources for disaster victims. And in their report, they were again citing that individuals in high-risk fire areas could all be impacted by disaster, but increasing resources in response to things like wildfires would be of most benefit to individuals who are low income or older adults, by helping them rebuild or making sure that they have access to meet their essential needs, such as food assistance or emergency medical assistance. And so again, this activity could impact a broad group of people because it encompasses all disaster victims, but that it would be of most benefit to indigent persons. And then the second activity from NLS was a policy report that they had produced in conjunction with Cal State LA, I believe, or Cal State Northridge, regarding policing of low-income communities in LA County in the Antelope Valley. They indicated in the report that this was a report that they produced where they went out and did community presentations on it, of the findings in the report, as well as sharing the report with community-based organizations that tend to be comprised of low-income individuals or represent low-income individuals. Yeah, sorry, go ahead, Catherine.
And I guess the question is there any concern about whether that's a civil legal service when you're looking at policing activities? And And has the bar staff talked about that?
Yeah, I think the report was talking about things, for example, like racial profiling and like civil rights related activities, but I do think there is maybe some overlap with criminal. This was probably the report that we had like the most kind of hesitation about or questions that not only for that reason about the criminal civil divide, but also that it's not really for advocacy with, you know, the legislature or even, you know, a city council, but it was really produced for community organizations to organize themselves or to use for them. So I do think there was some questions about it, but and I may not have, you know, all the answers. Like if there are specific questions about it, I'm happy to go back to NLS again. Like I said, I think this if there are questions, we can still resolve them by, say, the next meeting. But yes, Erica.
Sorry, just to kind of piggyback on that, and just really quick, is there any question among the staff about whether this is actually a legal service? Because it sort of feels a little like fact gathering, or
Yeah.
you know. So I'm just curious if there was thoughts on that.
Yeah, I think that it was also a question that kind of came up, is whether it would be considered a legal service. I know that they said it's used for advocacy, but for organizations to advocate for themselves, or I guess to increase their knowledge base, like you're saying about it's fact gathering for them to know about what's going on in the community. So
Yeah, and I'm not
it's
saying
not for like a specific change. They're not advocating for something.
Yeah.
You know?
I'm not saying fact gathering is not a legal service. I
No,
just wanted to get a sense of whether that was a concern at all.
Yeah.
It's like
Yeah,
Ganesh has her hand.
Yes.
Oh, sorry.
I know we're going through the presentation right now, but just I think that the questions are kind of moving in this direction. Will we, at the end of the presentation, be provided with the staff's recommendation on these?
Yeah, I mean, I think the recommendation at the last meeting was to approve these activities, but like I said, with the exception, I think of this particular activity, staff would recommend approval of all of these. This was the one that was a little bit more kind of on the fence.
Okay. Very good, thank you.
Mhm. Sorry, were there any other questions about this activity?
I don't think so.
Okay. Great. And then the last three activities were from Public Law Center. The first one had to do with identity theft. So they were advocating to improve reporting requirements, requiring that reports be taken when a person indicates that they've experienced identity theft, and that this would help with proving claims of identity theft that the person's made a report. They indicated that they felt it was disproportionately impacting indigent persons because of things like applying for public benefits and the vast amount of personal information that's required to do that, and that it's maintained online and is susceptible to being hacked or for people to steal individuals' information and then use their identity. Pamela?
I just wonder, are there not already organizations that are already doing this for the public at large?
The identity theft advocacy?
Identity theft, debt collection, are there not already organizations already doing these things?
Mhm.
And what's making the program their approach different than what's already for the public?
Yeah, I mean, I think that's correct, that there are other organizations that advocate around these topics. But the idea is that these organizations are are advocating because there's particular need among their client base or indigent persons in general, that they've identified that they feel it's important to contribute to the advocacy around these efforts, and in particular to represent the perspective of their client constituency in these activities to make sure that it's meeting their clients' needs, or that there isn't a decision made that's going to harm their clients further, that it is meant to improve things. So, I think the fact that other organizations may engage in this work or engage in advocacy activities related to this type of work doesn't necessarily preclude the organizations from providing their support or their piece of their perspective, basically. And then the next activity from Public Law Center was an activity related to medical debt and charity care. This was one that dealt with debt collection, specifically around medical debt. It did indicate, for example, that it would expand the pool of individuals who would be eligible for financial assistance up to 400% of the federal poverty level. But based on follow-up with the organization, they indicated that, based on their research, they have felt the majority were below 200% of the federal poverty level, and that even more so, the advocacy wasn't only about increasing up to 400%, but that they were specifically advocating around the fact that a lot of indigent persons were affected by these debt collection efforts without the hospitals having gone through the appropriate steps to identify whether the person should have been considered for financial assistance. And so it would reduce the number of persons inappropriately impacted by debt collection efforts when they shouldn't have been charged in the first place. So that was kind of the additional information provided by the organization. And then the last one was arbitration advocacy around adhesion contracts, which the organization cited, in the employment and consumer context, that a lot of individuals are required to engage in arbitration and may not wish to, but they don't have enough bargaining power to negotiate those contracts or to work around those things. And so they were citing the low-wage workers and indigent persons being disproportionately impacted by these types of contracts and inability to work around the arbitration requirement. Erica?
Yeah, just really quick, I can't remember, but what kind of advocacy was it? What were they doing?
Let me double check really quickly.
I see it, sign-ons to request for publication, amicus brief, analysis of appellate court. So it's sort of like legal research and some advocacy on legislation. I was just curious what they were.
Yeah, I think it was kind of a amalgamation, like it wasn't, that it was under the umbrella of arbitration advocacy, but they actually were doing a few different things. And as you said, it was around legislation and signing on to requests for amicus brief opportunities related to cases around this work. So I don't know if this past year, if it involved legislative activity or if it was only confined to amicus brief opportunities. But we have considered, contributing to or writing amicus briefs as qualifying. So,
Yeah, that's fine. I was trying to recall from this, like what the advocacy had been, and their view is essentially everyone benefits from this kind of stuff, but indigent people in particular have a lack of resources or lack of leverage is the idea. Okay.
Yeah.
Okay, that's all.
Yeah. And I think that's kind of the crux of it for really all of these activities, is any of them could potentially be impacting a very large proportion of the population. And it's not necessarily confined to indigent persons or even a majority of indigent persons, but that that it would be especially meaningful or helpful to their client population to see these efforts approved. So.
So do you want to provide us with staff's recommendations? Generally, you said your staff's view is to approve all of them, although maybe with a little bit more hesitation, the policing.
Yeah, yes, that's correct. I think we would recommend approval of all of them, but upon sort of revisiting that report from NLS about the policy report that they did, that we had some more hesitation around that. And so if there was specific follow-up that you wanted us to do before making a decision on that activity, we could do that, or yeah.
Great. Catherine, Pamela, Bonifay, do you guys have any questions, any thoughts that you want to share on these?
So I guess my question about the report is, there's a Rules Committee working group that's working on the definition of civil legal services, and it includes reports and sort of the, what reports would be included and what reports wouldn't. And I don't know whether Brady or Erica has a thought about that definition and the applicability, like how this report would be viewed under that definition of legal services.
Yes, I did consult that memo last week, so now it's escaping me, but I think that was part of why maybe we took a step back, because we had at the last meeting, we had recommended approval of this report, but I don't have a specific opinion, because I don't recall at the moment what aspect of it was what highlighted the issue. I know, I don't want to, go ahead. Yeah.
I mean, I don't see the definition being considered and discussed as any change. It's more fleshing out the detail. To take a step back, the one I had the most concern with was the policing, and I actually don't have a criminal civil concern about that, because they're not, the criminals really, you're going into court and defending somebody, is how I would define that, but more whether it's a civil legal service, a legal service, and at least as they've defined it, I think that's questionable. When they talk about the benefits, it's more advocacy, education, not about what's going on, not necessarily about legal rights or any specific legal violation.
Thanks, Brady.
The only other question was, were any of these programs denied in part for any other adjustments to qualifying work? And this is just like another bite at the apple to get some type of funding that kind of deviated from their primary purposes.
I'm sorry, I cut out a little bit at the beginning. You asked if any of these organizations had to make any other deductions for non-qualifying work. Is that the
right? Were they denied in part for any deviation to their primary purpose funding?
Yeah, so I know specifically at the last meeting, for example, Asian Americans Advancing Justice Los Angeles had an activity that the committee found non-qualifying related to redistricting efforts. But in general, a lot of these organizations have some element of or level of work in which they engage that would be considered non-qualifying. They might serve individuals who are over income. They might do activities like some of these where it might not be considered a civil legal service, or might be for, not for primarily for the benefit of indigent persons. So I would say probably all or most of these organizations have some level of non-qualifying work that in most cases they are pretty quick to identify and they deduct it voluntarily on their applications. So I wouldn't necessarily frame it as another bite at the apple. It's just that they, from their perspective in these reports that they've submitted, they felt that it met the standard. Reasonable minds may disagree on some of them, which is why we're looking at them more closely. But
I think maybe part of Pamela's question, or the question that I wanted to confirm, none of these determinations are going to, like, if any of these were pulled out, it's not like any of these aren't going to be eligible as a result, right?
That's right. Yeah, I think most of these organizations, I think, are pretty well above the 75% or presumption for primary purpose. And then many of these activities, I don't know if you noticed, not to say that you should draw a line based on the number of hours, but like we're low in terms of the number of hours. The NLS report actually was significant. I think it was about 350 hours, but a lot of the other activities, they were small. And so even if they were found non-qualifying, it wouldn't be a major hit to the organization's expenditures and then consequently their primary purpose. So even in the case of a high amount of hours, I don't think any of these organizations would be impacted in that way.
Thank you. I think Bonner had her hand raised, and then Catherine.
Oh, sorry. I think I was gonna ask Brady to weigh in, and he did. That was the basis for my hands being up, so I could lower it now.
Thanks, Bonner. Catherine.
So I think my question, which I think Brady was talking about, is the Neighborhood Legal Services report really a report to sort of do community organizing around? And if it is, I feel like consistent with the position we took with Asian Americans Advancing Justice, which is their census work was really much more for community organizing than teaching people about their rights or some other action that's going to lead to a legal action. So that to me, I mean, I haven't read the report, so it's sort of difficult for me to make that conclusion. But what I'm hearing is it's much more was being used as an organizing tool, and that seems more consistent with things that we have not allowed other organizations to count. And so I guess I would. If you feel like that that's how it's used, then I don't feel like the need for other information, and I would share your reservations about it. But if not, then I feel like we need to better understand how, what they were doing with the report and make a decision. But I think consistently we've said if it's for a community organizing purpose, which is incredibly valuable, I'm not disputing that, it's just not a legal service.
Right. I do think, and I agree. I mean, I haven't read the report itself, but based on their activity that they submitted, it was a little bit vague. It basically said, this has been provided to community groups and for their advocacy efforts. And so that it strikes me as you said, Catherine, more of a community organizing effort, but I don't know if I could say definitively the ways in which it's been used or what the intent was, just that it's been provided to them and they've found it beneficial. But it doesn't seem like there was a specific advocacy effort that it was being targeted with, but yeah, so I would agree. I would be inclined to kind of consider it more as a community organizing tool, but I can't say that definitively. So I could seek some more information around that if that would be helpful.
Okay. Do we think it would be beneficial to just get more information, or are we inclined to deny at this point? Do we have any sense? I mean, I'm looking at their application and it does sound like there was some press around it and they sort of did a big report or did a big kind of media push. And then there was maybe some follow up from the Inspector General of LA County, but I don't know if they were advocating. So my inclination is like if they can provide a nexus between the report and legal services, I'm more inclined to approve it, but at this point, I agree with, I think everyone else that there's not that nexus so far. Do you have any other questions on this one? Okay. Without any other questions, my suggestion would be a sort of a motion to approve all but the not just stops policing report. And then on that one, I don't have a problem giving them another opportunity to provide us with more information, but I'm also fine, sort of being like, you guys, you've had your shot. I'll defer to other people on their views on that.
I think it really comes down to, is there anything further they can provide given the rubric and the framework in which we work within? And I don't know if there would be anything further. So I would move to accept the staff's recommendation in whole.
Montache, it's Catherine. So I think the recommendation we're referring to is to approve those except the not just stops policing report based on the concerns staff articulated about it not being a legal service.
That's correct.
Okay. I mean, I'm fine with that. So essentially we would approve all but that one and then deny on that one.
Yes.
Is that the idea? Okay.
That's correct.
Erica, do you think we can put that into one motion or do you think it would be better to do two motions on that?
I think you could put it into one.
Great.
So I think that's the motion Bonachet made.
Yeah.
Okay. So if that's the motion from Bonachet, is anyone seconding?
I would second the motion.
Great.
Connolly,
Yes.
McClug,
Yes.
Fate Master, Bennett,
Yes.
Blakemore,
Yes.
Klein, Meeker. The motion passes.
Great. Thank you for the useful discussion and for all the information, Erica. Okay, our next one is the request by California Welfare Rights Organization about their reviewed financial statements.
Yeah. So as I was mentioning before, that audits are required as part of the ILTA EAF application process. The organization has to submit their most recent audited financial statement from the prior fiscal year. In the state bar rules and the schedule of charges and deadlines, there is a threshold of $500,000, which is set as the cutoff for organizations below that in terms of their gross corporate expenditures in the prior year. They can submit a reviewed financial statement, which is a little bit less intensive than an audit. It essentially saves the organization money, and the auditor, engages in some of the same activities as an audit, but it's just not as in-depth. So smaller organizations can do a reviewed financial statement. Any organization above $500,000 in corporate expenditures would need to submit an audit. The Coalition of California Welfare Rights Organizations is a longstanding support center receiving IOLTA and EAF funding. They have typically been a smaller organization. Since the inception of the program, they've always submitted a reviewed financial statement because they've never kind of broken that $500,000 threshold. For their fiscal year in 2021, their expenditures were slightly above the $500,000 mark. It was $503,654. This is the first time they've ever kind of reached that level. They submitted a reviewed financial statement in lieu of an audit. And so we had brought it to the committee to consider the potential for them to use the reviewed financial statement in lieu of the audit, but based on our research of, looking at the rules and the schedule of charges and deadlines, that requirement does not seem to have any wiggle room. It's not very flexible. So it's staff's opinion that they would need to comply, excuse me, and provide an audit. Based on our follow-up with the organization, they were willing to try to engage an auditor to, to obtain the audited financial statement instead of the review. Based on their report back to me, they will need several weeks, I guess, to finalize that. And so our recommendation would be to grant them an extension, because they did provide something. They provided a reviewed financial statement from a certified public accountant. It just wasn't the right documentation. And so we would recommend giving them the opportunity to correct the error, because it was a genuine error and this is the first time that this has happened. But we do have some concerns with them being able to meet the deadline, but staff would really push them to try to get that done before eligibility determined, or before allocations are run in August. Catherine?
So thank you. You actually answered my question, because I looked, I mean, when it's a rule, it feels like we have to follow the rule. So I thank you for answering the question, and I agree with your approach, which, I guess it's unfortunate. It's, $3,000 above it, but the same thing would happen on the federal audit threshold, which is also 500,000. And to my knowledge, there's no exception under the federal threshold either. You're either below it or you're not below it. So, and I agree with you. They clearly would need an extension, and so I agree with the approach.
Dawn?
Hi, everyone. Sorry, I apologize for not being on time to the meeting, but I do have a follow-up question, because I know I spoke to Erica Carroll last night about this after Brady did a little bit more research on this, and I think came to the same conclusion Erica and I did, which is that there isn't much wiggle room. My one question though for Brady, maybe Brady and Erica have already talked about this, is if they submitted a draft version, because I'm concerned that they're not going to hit the August deadline, because sometimes audits just take many months. So if they submitted Brady a draft by August, is that sufficient? Or I don't think our rules technically say it needs to be a final. We've imposed that. I think that it needs to be final. Will that give them a little bit more wiggle room?
Well, I mean, I don't want to give any wiggle room at the outset. I think that's something we might be able to consider at that point if the audit, if the auditor says, here's my preliminary, here's the caveats. And, I think at that point, because there's no definition of what is an audit, I think that we could at that point probably consider, entering some agreement that says, hey, okay, here's your numbers. We're going to run the allocation on this, make sure we get the final. And if the numbers change, basically, if they change to your advantage, they go up. Too bad, you're getting the allocation. And if they go down, you're going to get a reduced allocation because the like you said, there's no clear definition of what is an audit. So maybe at that point we could decide to accept a preliminary. But the policy is clear that we can't hold up the allocations. So we'd have to basically hold them to this is the most you're going to get. You might get less.
Okay, and maybe they'll be able to.
I don't think that's a decision to make now, because I think for now we should assume that they need to.
No, you're right. That sounds right. And I think best case scenario, hopefully this will pan out, that because they have a financial review, maybe the audit will only take a few weeks or 2 months. It won't drag on. It's just okay. That sounds like a great approach.
And I'd rather. The price for the audit wasn't huge, so if they can pay an expedite fee, I think that would be, reasonable, and lessons learned for next year.
Yeah.
Wanna you have your hand raised?
You may have just answered my question with the last few words, Brady. Has this occurred for this organization in the past? Has there been delays of such in the past? No. Okay.
Not that I'm aware of.
The organization has not related to audits or like reporting they don't have a history of being late. This was really an honest mistake. Because it's only $3,000.
Yeah, it sounds like it.
Anticipate that they go over the threshold.
Yeah, it sounds like it. I'm not sure if we want to move to, do you need a motion on this?
Yes, so, I mean, you can wordsmith it, but essentially the recommendation from staff was to recommend approval of an extension. So not accepting their reviewed financial statement, but approving or recommending approval of an extension through the allocation date for them to provide an audit.
So I understand this, and I'm not opposed to it at all. The one little wrinkle I'll say is we were a little bit stricter on the deadlines for other entities who were having a hard time getting their audits in, and had said we really needed them earlier than the allocation. And so I just want to make sure that we're clear as to why this is a little bit different than those other organizations. I'm not saying we shouldn't treat them differently, but I do want to be clear if there's a good way to explain it.
What my understanding was, and again, I didn't talk to them, so Erica, correct me, but sort of that, they've been going along for many years at the, just under 500, and I don't think there was a major change that made them expect that they were going to be, crossing a threshold. Perhaps they should have caught that earlier, but it seems reasonable, and this is a extenuating circumstance for them for this year. I think in the past it was more, an audit's hard to get. We needed more time, and it's like, well, no, everybody's facing that same. That's my sense of how this one is different.
Yeah, I think.
But you guys have the discretion if you disagree.
I just want to make sure we've satisfied our extraordinary circumstances standard, and it sounds like we have, and I assume we have some assurances from them for next year that they're going to be kind of on the ball with this. And
Yes.
great. Okay.
I think,
like I said, I'm not opposed to this approach at all. I just want to be clear.
Yeah,
that we're treating everyone fairly.
I think the distinction, or one possible distinction between this organization and some of the others, is the others hadn't, we either didn't even have a draft, or this does have a reviewed financial statement from a CPA, so there is some ability, I would say, to rely on the information. It's just not as, it's only limited assurances instead of reasonable assurances. So we do have something from them in terms of them meeting a deadline and thinking that they were complying with the requirements, versus some of the organizations that you and Catherine were looking at. We didn't have anything from them to even start kind of reviewing. At least with the reviewed financial statement, we could start that review, and then, once we get the audit, go back and confirm and make sure it's matching up, or that there are no further changes required.
The huge irony, watch, the auditor is going to find they overstated their expenditures by $5,000.
Yeah.
That would be ironic, but also probably good for them to have an audit if that's the situation. Catherine.
So I guess the only outstanding question is for other programs. What we did was require them to put in writing their assurance that this wasn't going to happen for the next year, and that they would sort of be aware of their level of expenditures and their need for an audit. And so I think, to Erica Conley's consistency point, I think it would be good to require them to submit that same kind of letter, so that we're treating all programs the same. I don't have a problem with the recommendation. I think there's a good basis for the distinction, but I think that just sort of in that sense of equitable treatment, that we have them put in writing whatever they've told you informally about how it's not going to happen in the future. So maybe that gets added to the motion.
Erica, is it better, I don't feel strongly, instead of saying the date of the allocation, do we want to give them a specific date? Like call out that date?
Plus, don't you need it a few days before the I mean, you need a little time to process it, right? Like a week before the allocate, I mean, whatever
that's
that date
fine.
is, I feel like.
That leaves it a little vague to me, but, I mean, technically, we run it, so the commission meets on the 12th, and then the Monday, like that, it's like go time for the staff. They're geared up, but yeah, optimally, it would be sometime, I think that the week before, I mean, that week of the 12th, earlier in the week, maybe. So then we can do report back to the commission.
The week of the 12th.
I think so. The commission meets on the 12th to vote
Yeah.
on
Well,
eligibility.
allocations aren't actually determined until after, like, when we run the formula, which is
We
not
run
on
the
the 12th, so.
Yeah, we don't literally run it on the 12th. We gear up the following 2 weeks to run it, but it would be good to go into the following Monday with the number so that staff, it doesn't delay that.
Okay.
Should we say like maybe August 8th, 9th, 10th, somewhere in there?
That's what I would recommend. Because you all have a meeting the morning of the 12th, because then you can build it as an agenda item.
Mhm.
2 days prior to the meeting, that's not cutting it too short or too close?
I think,
There's nothing we need to do on our end.
There's nothing, okay.
I mean, we would just report back out, right, Erica?
yeah, I mean, I think, again, as long as the audit confirms what we already have in the reviewed financial statement, it would just be checking to make sure it matches. If there was some variation, then it may require them making an edit to the application, which by that point, staff should be finished with all of our review of any of the other applications. So hypothetically, we could follow up with them and have them do it immediately. Yeah, so we wouldn't necessarily be juggling that with review of all the other applications at that point. Everything else should be finalized. So.
And the support center application is a lot less technical than the QSPs, because you all know it's we have to get their qualified expenditures number correct, but we don't need it. We don't need the county allocation. It's just less technical. It's less cumbersome for us to review. So I think if there's follow-up, it'll be nominal. We definitely just need to make it match the total qualified expenditures. So that's an easy, it doesn't take us that long.
My only other concern on this sounds all good, is if they can only get us a draft in on the 10th, if we can just put in the agenda in advance that, like, make sure we play out that if it's a draft, we will approve the draft element. Just, I don't want us to be stuck where they can only get us a draft, but we didn't notice it, and so we can't vote on whether to accept it. Does that make sense?
Yeah, I think we just build it broad, Erica, like.
Okay, that's
like
fine.
a
Yeah, I just want to make sure.
discuss. Erica and Brady and I can figure that out.
Yeah, that's perfect. I just want to make sure we have flexibility in, for them as well. Awesome. Okay. I'm happy to make that motion. Does anyone second?
Catherine will second.
Connolly,
Yes.
Cloggy,
Yes.
Fight Master, Bennett,
Yes.
Blakemore,
Yes.
Klein, Meeker. The motion passes.
And I would just, I think staff already knows this, but if you guys just stay in touch with them and, if there's any issues, hopefully they will communicate to you earlier than later.
Mhm.
Thank you so much. Okay. Our next one is late submitted. And we're all about deadlines on this one. Okay. These look good though. Not
Yes.
too late.
So briefly, the application was due on Monday, May 16th at 5 p.m. We had a few applications come in after that point. As you can see, 2 of them were within an hour of the deadline and 1 was the next morning. So Youth Law Center, our best guess is that there was, a delay because there were a number of organizations trying to submit at the end there. So I think it was just a delay in processing it when they click submit. Legal Aid Foundation of Los Angeles was having some technical issues that they reached out to us about. And so staff worked with them to address that so then they could submit it. Which
they reached out to me like that morning, I think the night before, because they were really concerned, and we would try to that when I felt like they had it in, it was tech issues.
And then Legal Services for Children, they believed they had submitted the application. That's why it wasn't in. They didn't actually make any changes. Once we brought it to their attention, it was still in draft status. They just thought they had submitted it, but didn't get a confirmation. And so then once they realized, they went back in and submitted. So none of these delays were for substantive reasons. And so staff would recommend approving or accepting the late applications for review. The only other thing I wanted to mention, which I think was in the memo, is that there is currently a recommendation from the commission that if it goes through public comment and it's incorporated in the rules, it would allow staff to have discretion. In the case of all 3 of these, staff would have had discretion to accept these, and we would have accepted these applications because they all came in within 1 business day, and there was a reasonable explanation for the delay. So that it is still up to the committee at this point, but in the future, staff would follow a similar course of action and would recommend approval of the late submitted applications. So.
Great, thank you. Any questions or concerns? Seeing
Catherine,
no
I'll make a
hand-
motion to approve staff recommendation.
Any seconds? I'm happy to second.
Thank you. Connolly,
Yes.
Naklagi,
Yes.
Master, Bennett,
Yes.
Blakemore,
Yes.
Klein, Meeker. Okay, the motion passes.
Great, thanks. And then our next one is about eligibility review conferences. Or
Yes.
is it- Yeah, go ahead, Erica. Thank you.
Sure. So eligibility review conferences, they come up during application review sometimes when we have applications that present significant eligibility questions that the organization may be in danger of not qualifying for the grant. I would say it comes up most often with new applicants, but we sometimes do have existing grantees that are not meeting the presumption of primary purpose, or there are just a lot of gaps that need filling in terms of understanding the services they're providing. And so we usually have a few of these each year. It is a meeting that we would schedule between the applicant and then members of this committee, as well as state bar staff, to clarify any of the issues and have a better understanding of the application before moving on to eligibility determinations. So staff is in the process of continuing to review all 102 applications that we've received. And we have a few that might need an eligibility review conference, but we'd like to kind of spend a little bit more time following up with the organization before determining if that's necessary, or if we can gather the information we need through some limited follow-up. So typically we would ask the committee for permission to schedule these conferences and give you some information ahead of time about what our concerns are. But given the nature of this sort of compressed timeline for review, and that the next meeting won't be until July 15th for the committee, what we would be asking is for the committee to delegate authority to staff to make that determination about whether a review conference is appropriate. And then we would schedule them as needed between now and eligibility determination. So there's no undue delay. If we were to wait until the July 15th meeting, that only gives us a few weeks before eligibility determinations, and might be a hardship for committee members to make time to attend. It might be difficult for applicants to schedule. So in the interest of everybody's time, that's why we're asking for permission to schedule those conferences without advance approval for it.
Thank you. Any questions or comments from committee members? Okay, having heard none, does anyone want to make a motion?
I will move the motion.
Thanks, Catherine. Anyone want a second?
I'll second it.
Thanks, Pamela.
Thank you. Connolly,
Yes.
McCloskey,
Yes.
Fightmaster, Bennett,
Yes.
Blakemore,
Yes.
Klein, Meeker. Okay, the motion passes.
Great. That's the end of our agenda, huh?
Yeah.
20 minutes to spare. All right. Thank you, Catherine, Pamela, and Bonachet for being here so we could have quorum. Yeah, and now we have an hour plus off before our next meeting. And thank you to staff as always. Great work on everything. And Erica, thank you for getting everything put together. And Brady, thank you always for your advice. Very helpful guiding us through what we can and cannot do. So thank you all, and we'll see you in a little bit. Enjoy some lunch and some break time.
Thank you.
Thank you,
Bye.
everyone. Bye-bye.
Bye-bye.